All right, everybody. Welcome to the show. This is Phil Ferguson, and you are listening to the cleverly titled The Phil Ferguson Show. And with me today, I have John McNair. He is an attorney in Texas, and we're going to talk about trusts. And John, before I get too far into this, I want to make sure I understand this correctly. And I want to make sure my listeners understand this correctly. If they want a trust or if they have legal questions, they probably should consult somebody in their state. Is that right?
Absolutely.
Yeah.
Every state has different rules about their trust, their related estate planning documents. It is very state oriented, and most attorneys are not entitled to practice outside their particular state. I'm only
Right.
licensed in Texas. I'm not licensed in any other state. So they truly need to have an expert in estate planning and elder law in their particular state.
Just popped into my head. How long after my death, if I have a trust, how long can I control from the grave? Is the phrase I use. I don't know if that's the right thing to say. How long is that allowed in Texas?
So that's an interesting question.
Thank you.
Uh, we were like most states from English law for most of my career, and we had something called the rule against perpetuities.
Yeah.
And the rule against perpetuities says that a trust can last for lives in being plus 21 years. So you've talked, as we have waited to start this, about your children. I'm assuming they're adults since they were talking to you as if they were adults in
Yes.
your conversation. And if they have children, under the rules against perpetuities, you could keep it open for their lives and the lives of your grandchildren that are alive when you die. And then at the end, then it goes away. A few years ago, Texas followed a trend of a lot of states where they are either modifying or eliminating the rule against perpetuities. And in Texas, they modified it. You can't make a trust last forever in Texas. You can only make it last for 300 years. And there is a question in Texas whether that's constitutional under the Texas Constitution.
Yeah.
Most of my clients don't have enough wealth that they want to keep it around for 300 years.
Yeah. My wife and I, just one of the inspirations for doing this now, my wife and I were just meeting with an attorney in Florida where I live.
Mhm.
And her perspective was pretty much in the state of Florida. It's forever. Whatever kind of rules we want to put on it, we're not doing that. But
Yeah, that's one of those states that has eliminated the rule against perpetuities, I'm assuming, based on that conversation.
yeah, it's so this is just one of hundreds of little details that can come up while you want to talk to somebody in your state. As usual.
May I point out the
Yes.
conundrum that I've always worried about if you
What's that?
decided to do something like that?
Yeah.
Let's assume that you felt like you had a large enough amount of wealth to do that. So how would you structure that trust for multiple generations going down the line? Would it be what we call a pot trust? Would it be one trust for all of those generations? And let's assume that you could find a trustee for that, like a corporate trustee.
Right.
They're the kind that would take those. Are they going to be happy? I'm not talking about the corporate trustee. I'm talking about your beneficiaries down the line,
Yeah.
knowing that every time their cousin gets some money, that's money out of their pocket. They're not getting that. And why is that person getting it? Why am I not getting it? And so you're creating the potential for conflict among your generations.
Yeah. Because
Okay, well, what's the other alternative? They talk about cascading trusts where every individual beneficiary gets their own trust.
right.
But if you had a $10 million trust, down the road, would each person have such a small trust as it got to great, great, great grandchildren? Would it be worth the effort to keep that trust in place?
And I don't know about in Texas, but here in Florida or Illinois, a local bank, for example, uh, that has a trust department, they will often want something like a flat annual $5,000 to $10,000 a year, and then on top of that, they're going to want something to manage the investments.
I
So
haven't seen too many that have a dollar figure. Most of them want a percentage of
yeah,
the assets under management on an annual basis.
yep.
And I think it's usually a percent, 1%, give or take some basis points.
Yeah, I've seen as low as 1%. I've seen higher, 1.5. But I've also
The
seen
smaller the trust, I think the higher
yeah.
there could be.
Well, and that's where they'll have the floor where they'll say it's 1%, but a minimum of 5 grand. So if your trust gets to be 100,000, they're sucking out 5 grand a year,
Right.
minimum for them to do it. So it can consume it. So you might want to have some language that says if it gets to a certain point, it liquidates.
I do that. I
Yeah.
have that specific language in my trust, and I usually pick 100,000.
That's a good number. Before we get into too many more fun details, and we're learning all the time. So this is the point of this. I want to go over the main factor that divides trusts into two different categories, and I think the best way to do that is revocable versus irrevocable. Can you walk me through what those words mean?
Right. Typically, a revocable trust is one you established for yourself. You create a trust in which you are the trustee, you are the beneficiary, and you can revoke it, amend it, or alter it at any time. As a result, it is not intended to be well, there are some states where this is not true, but in most states, this is a trust that is not creditor protected. It is not intended to be a creditor protection device. It doesn't, in and of itself, a revocable trust is not an estate tax planning tool.
Yeah.
You embed estate tax planning tools within a revocable trust. But I use revocable trust for two primary reasons. I believe it is a superior way to manage your assets for you if you became incapacitated, as opposed to relying solely on a power of attorney. I have seen many financial institutions that have given my clients, agents, difficulties when they tried to show up with a power of attorney. So I try to avoid that. It does avoid probate. Texas doesn't have a terrible probate system, but it depends on your state whether your probate system is difficult or not.
Right.
So those are the two primary reasons for a revocable trust. An irrevocable trust is, by definition, not revocable, amendable, or changeable. And it is typically a gift trust. You're either creating an irrevocable trust for somebody else during your lifetime, or the discussion we just had, an irrevocable trust for somebody else after you die. Your children each one of your children gets a portion of the vast Ferguson empire in trust, and they become their own trustee of an irrevocable trust. They get to use it for their own health support and maintenance. And that trust can protect that asset from their creditors and their divorces because they didn't create it. Somebody else did, you in my scenario. And as a result, you can put in that trust something called a spendthrift clause. Audience shouldn't care how that trust is creditor protected. Just the point is it's creditor protected because you created it for somebody else, not that person creating it for themselves.
Now, could I create a revocable trust that I control? It's mine, not necessarily separate from creditors or whatever. But when my wife and I pass away, it has instructions to create two irrevocable trusts.
Exactly.
For each one of my children, so that if at some point in the future they marry a moron and then get divorced and that moron wants to take half of it, they can't have it.
Exactly. That is exactly the model we use. That's what happens.
Now, also in a irrevocable trust, if I did that while I'm alive, let's say I had $1 million and I put $1 million in an irrevocable trust, and then I get sued for $1 million, is that $1 million now protected and it's safe from creditors?
You made a gift of $1 million into an irrevocable trust for your children in your scenario.
Well, I'm just saying, irrevocable trust that while I'm alive,
You
I
can't create a trust, an irrevocable trust for yourself that will protect
okay,
you from your creditors outside of a few jurisdictions. South Dakota, I think, does it. Uh, Alaska was the pioneer state, maybe Delaware.
yeah,
I don't delve into that very often, but if you make a gift, let's just use a standard issue state where they don't have those types of self-settled irrevocable trusts that are creditor protected. You would be making a gift into an irrevocable trust for the benefit of somebody else, presumably your children,
right.
and it will be protected from your creditors if you have not triggered a problem with the Fraudulent Transfer Act. Every state has implemented some kind of fraudulent transfer act where they basically say if the creditor can prove that you transferred that asset in anticipation of avoiding your
Ah,
known debts or potential debts, then the courts would have the ability to reach out and pull that asset back out of the trust and give it to your creditors.
and
It
how
comes up where you know that you've been in a car wreck and you've been sued, and uh, you make a gift into a trust. You haven't had a judgment against you at that point, but
right.
you knew there was a potential for those creditors
Yeah.
to come after you and get a judgment later. So that would probably be a transfer and fraud of creditors.
How about in relationship to Medicare, Medicaid? You know,
Medicaid.
you're
Yeah.
64 years old, and you're like, wow, I want the most I can get from Medicare, Medicaid, or if I go in a nursing home, I don't want to have to pay for it because I don't have any money, so I put it in a trust. Is that going to play?
So how that works is it's Medicaid, by the way, that pays for long-term care. And a gift in Medicaid land is something that creates a penalty, a period of time in which you are not eligible for
And
Medicaid.
that's the look back period.
Well, let's divide things up. Before we get to the look back period,
Yeah.
there's just a penalized gift, and each state creates their own penalty divisor. Like in Texas, our penalty divisor ends up being roughly this year, and it changes every year based on inflation, but roughly just below $7,400 per month. So if you gave $100,000 into a trust for your children and an irrevocable trust,
Yeah.
and then immediately applied, then you divide $7,400 into if that 100,000, I don't know how many, it'd be more than 12 months.
Yeah.
But that many months you would not be eligible for Medicaid.
Ah.
Now, let's talk about the look back period. The look back period is the period in which you have to report prior gifts on your application for Medicaid, and those gifts, if you have to report them, will create that penalty period. And the penalty starts from when you apply, not from when the clock is ticking, not from when you made the gift, but when you apply. And the 5-year look back period is the reporting period. You don't have to report gifts that you made more than 5 years ago. So if somebody were going to implement a plan in which they made a gift into an irrevocable trust, they would be betting that their health is going to hang on for the next 5 years, and they don't need that money. They've got other sources. They have a high enough monthly income to cover care if they needed it during that 5-year period. But after 5 years, they wouldn't have to report the gift into the trust, and those assets would no longer be countable resources. If you're a single individual, you can't have more than $2,000 of countable resources. There are much more generous rules if you're a married couple,
Yeah.
the spousal impoverishment rules, which would take us hours to explain. So I'm not going to do that right now, but just be aware that a married couple might not need to do that as much as a single person might.
Sure. Now, what kind of total assets do you think someone should consider getting a trust? I mean, if someone's got $10,000, probably not necessary. 5 million, yes, but where's that line?
So I feel like it's a combination of what type of assets you have and numbers. Because if you have real estate, you should probably consider a trust.
Yeah.
Your residence is going to be several $100,000, almost assuredly. If you don't have one and the only asset you have is an IRA, well, A, you can't put an IRA in a trust, and B, it's not going to go through probate anyway if you have proper beneficiary designation. So you might not need that. But if you had a couple of $100,000 of cash and a trust and a house, a revocable trust would be an appropriate thing to consider.
It popped into my head another question here. What if you have, let's say, $1 million IRA and you have two kids? So on your death, they each get 500, assuming you put them both as primary 50-50 beneficiaries, equal split. But instead of going to the kids, that goes to the revocable trust, which then becomes irrevocable on your death. And that would allow you to control from the grave and spoon feed out the money so they don't get it. But then it also probably fucks up tax consequences.
So the way that works is this. A few years ago, I'm sure you're aware of this, Congress changed the rules, and if you're not a spouse, you basically have to pull everything out of an inherited IRA over the course of 10 years from the date of death of the decedent. And
Yes.
so by the anniversary date of the 10th year, it's all got to be out of there. I recommend to my clients these days that create a plan like we've talked about. You have your own revocable living trust, and when Phil Ferguson and his wife pass, it goes to their two kids. Those two kids then have irrevocable trusts that are created for them. And Phil Ferguson, instead of naming his kids individually as beneficiaries or his living trust, that's not a good beneficiary either for these tax rules. He
Okay.
named specifically John Doe Ferguson, Descendant Trust, Mary Jane Ferguson, Descendant Trust, as the two beneficiaries. And then two inherited IRAs will be created, and those two IRAs will start sending the money down over the course of 10 years. And by the end of the 10 years, the inherited IRAs will go away because there's nothing left. Right. And although you've had to pay income taxes, it's gone down the line. There's no alternative. That's going to happen.
Yeah.
But you've captured the money in a creditor protected and a moron son or daughter-in-law proof trust.
Now, would the taxes be due year one?
They
Or
are due every time there are required minimum distributions as they are pulled out of the tax-free environment of the IRA. And remember, 1/10 of the IRA has to be pulled out. The IRS put in place some regulations last year.
Yeah, about the
They
RMD.
could have said that you don't have to pull anything out until the 10th anniversary, but that's not what they said. They said you have to use your actuarial life as a beneficiary. Your son and your daughter have to each use their own life over that 10-year period, and then whatever's left over in year 10 has to go out. But it's all going to the trust, and as it's going to the trust, it's subject to income tax.
So
Whether it's taxed to the trust or to your son or daughter depends on what they do with the money once it gets in the trust. If they leave it there the entire year, it will be taxed to the trust. If they pull it out and put it in their own pocket and spend it so it's not available to the moron or to the creditors,
yeah,
then it will be taxed to them.
and of course, a trust in this case, the scenario, the irrevocable trust, whatever taxes it owes from the IRA will be at a very compressed structure. So anything over like $12,000 or $13,000 of gains will be 37% tax.
That's right. That's why I talked about possibly deciding to pull those out. But you give the discretion to the child. I mean, they might decide we're investing in other things inside the trust to offset that income tax liability, if indeed there are such things you can invest in. That's your area of expertise.
Right.
But maybe you offset and you don't have so much taxable income, and you're doing strategies to deal with that, or you just pull it out and spend it.
Yeah. So who own like so I have $1 million and I split it up upon my death, and assuming my wife dies with me at the same time, and I got two kids. So $1 million, 500 goes to the boy, $500 goes to the girl. Um, is it liquidated that year and the taxes are paid? Or you're
Are you talking
thinking,
about an IRA?
yeah, an IRA that the
No,
trust can
no,
drag it out
no.
over 10 years.
There's inherited IRAs that are sitting there. You don't want to
Yeah.
liquidate it, then you'd subject it
Right,
to
right. But
income tax all the first
who
year.
owns the
The
inherited share?
trustee. The trustee has control.
The trustee, but the trust owns it.
The trust owns it,
Okay.
subject to the control of the trustee, your son and your daughter in
Because I
this.
was thinking if you did that, it would have to be liquidated right away.
No,
But you're
it has
thinking the
to be
trust could
liquidated
follow.
based, it has to be liquidated based on the IRS rules.
Right. And are the IRS rules, and this is tax question, so may not be your expertise. What's the lifespan of a trust then? Or is it based on the lifespan of the recipient, the beneficiary of the
The
trust?
10 years is based on the lifespan of the. So first off, you have to create a trust where the IRS can see through the trust and figure out who the measuring life is.
Okay.
And that's the job of the attorney, to draft it in such a way that it is an appropriate accumulation trust as opposed to a conduit trust. There are trusts that can be drafted. A conduit trust says every time an IRA distribution is put in this trust, it must go out to the beneficiary.
Right.
I don't like that because I want to give them discretion. Again, as you pointed out, it may be an income tax negative to leave it in the trust, but I want to give that trustee child the discretion to figure out, is there a way to keep it in there? Because every dollar kept in the trust is creditor protected and divorce protected.
Yeah.
But if we draft the trust right, they are the measuring life. The son and the daughter are the measuring life, and it comes out over 10 years because the IRS has been able to determine there is a primary beneficiary. But the trust lasts forever. Any dollars that you haven't
Right.
distributed to the child stay there as long as you 300 years if you want.
So you could theoretically, while the IRA has to be liquidated by the trust and is subject to trust taxes based on the IRS rules, the trust would have to liquidate and pull money out of the IRA, but it wouldn't necessarily have to dispense all of the funds. For example, you could put a thing in there saying the beneficiary only gets 5% of the portfolio every year for 20 years.
You could do that.
Yeah.
And we have done that in cases where we have I've done that a lot with marital trust, where we have a blended family and we
yeah.
have a second spouse and children from the prior marriage. And the children from the prior marriage are the remainder beneficiaries. I've used that payout scheme. It's called a private unit trust in estate planning jargon. You establish it typically as 5% of the value of the assets calculated annually has to go out to that primary beneficiary. And in this case, with a marital trust, that's perfect because then you're not fighting between the stepmom or stepdad and the children.
Right.
in a trust for your own children, you typically, I have done that once or twice where the guy didn't, it's always a guy, didn't trust his children to be prudent with spending it.
Yeah.
But usually it's a HIM standards, health, education, maintenance, and support. The beneficiary can distribute for health, education, maintenance, and support.
You
And
mean
that
the trustee can
the
distribute to
trustee,
the,
your
yeah, yeah,
child can distribute to themselves and to their own children
yeah.
for their own health, education, maintenance, and support, and the health, education, maintenance, and support of their particular children.
And I think,
And so that gives them the discretion whether to pull it out in the year that the IRA distribution is received or not.
yeah, I think the nice thing that we've probably confused enough listeners with the beautiful nuance of all this that they need to hire a fucking attorney if they do this.
It's probably a good idea. Yes.
And I have another question, but before we do that, I don't want to forget. If you're in Texas, how can people reach you, John?
So my phone number is 469-210-8371. And my email is jmcnair@mcnair-dallaslaw.com. Or they can go to my website, which is mcnair-dallaslaw.com.
Excellent. And of course, if you're not in Texas, maybe you could contact John and see if he knows somebody not in Texas. But you do need to hire an attorney in your state. It's very important. The rules vary by state. The other thing that I had in my mind was, what about, I think it's a charitable remainder trust where I want to keep living off the money, but when I die, the money goes into a charity. How does that work?
So I don't see many people setting up charitable remainder trust to start when they die.
Okay.
Most people do that while they're alive. And there's a couple of reasons for that. Number one, there's an IRS rule or maybe a statute, congressional statute that says and I know this is a difficult concept, but if actually looking at the term that you set for that trust, the remainder going to beneficiaries other than, or the charity,
right?
You've got lifetime non-charity beneficiaries. If the value of the interest going to the charity is less than 10% calculated at the point that trust is established, it doesn't meet the test to be a charitable remainder trust and get the tax benefits.
Because there's nothing left. I mean,
so you can't predict when you die what will be the actuarial remainder interest going to that charity, because you don't know how old your children will be at that point.
Yeah.
So, and the second reason is the primary reason people set up charitable remainder trust, I think, is because in essence, it's an income tax play to change what would be a large capital gain event into something that looks a lot like a sale for a promissory note, where you get taxed on that gain and over a longer period of time. Because if you sell a closely held business and you're selling stock of your business, and you started the business with nothing, and now it's worth $20 million, there could be a lot of gain in that, and it'll be all taxed to you this year. If you were able to gift that to a charitable remainder trust prior to selling it, and so the trust is selling it, not you, then the charitable remainder trust rules are that you, as the primary beneficiary while you're getting it, let's say it's you can do it for up to 20 years or life. Most people don't do life. Over the course of that 20 years, part of that payment to you is being taxed as a capital gain. And so you're stretching out your gain. You're not getting it all taxed. You're deferring capital gain over the course of the life of that trust. That's why most people do that. Now, there's a lot of complicating reason why that doesn't work. A lot of times, the buyer is not real thrilled with buying from a charitable remainder trust. Most people don't bother to think about it and talk to their attorney until after a letter of intent has already been signed by the buyer, and it's too late at that point for the IRS. So it doesn't happen very often, but that's the primary reason people create charitable remainder trusts, I think.
Very good. Is there anything we haven't covered that you want to make sure we get in on this little chat?
I just would say don't forget all of your ancillary documents related to your estate plan beyond just the revocable trust. As we've talked about, you may very well almost always still need financial powers of attorney because, again, most people have retirement accounts that can't be placed in a revocable trust. Make sure you have medical powers of attorney so somebody can manage your health for you if you can't do that for yourself. Make sure you have a HIPAA release so that your medical agent has access to your medical records. Most people want to put in place an advance directive so that if they're put on life support systems and they're in a fatal condition and they have no chance of recovery, if they don't want to be maintained in that state, then they can say to their family and their doctors, take me off and keep me comfortable. Excuse me. And those kind of related documents.
Right.
Talk to your estate planning attorney about making sure you have all of those, not just the trust.
Excellent. Well, John McNair, thank you for educating and confusing us all at the same time.
About
like
that.
the important thing is, we just start thinking about these ideas, processing these thoughts. And if you think it's the right thing for you, make sure you get an attorney in your state. That's really important. And I would go further. And just like you were talking about, make sure you consult with a tax professional and make sure you consult with your financial advisor to make sure it all kind of works together, because you don't want to think you're doing something clever that ends up screwing you. So,
Exactly right.
John,
When I do estate planning, I think it's a team effort.
Yeah.
I would like them to have their CPA and their financial advisor as part of the planning process.
it's a funny thing because I know that there are, especially the bigger brand name companies, where they'll have a CPA and an attorney and an advisor all on board. I get a little scared about that they might always be thinking about how it benefits them, the company that they work for. So that's why I really like someone like you, independent attorney, an independent tax person, independent advisor that can share emails back and forth and kind of all sort of agree that this is an okay thing for you, the end customer.
Right.
John, thank you so much for your time and joining me here on the Phil Ferguson Show.
Thank you.